Imagine waking up one morning and realizing that a single sentence in a courtroom could change where your child sleeps tonight. Not because you did something dramatic, not because there was some shocking scandal, but because the law quietly shifted and you didn't know. That's the part no one talks about. Family law doesn't usually explode across headlines like criminal cases or political drama. It changes quietly, subtly. And yet, those changes can redefine your rights as a parent overnight. Right now in America, family law is evolving. Across multiple states, lawmakers and judges are rethinking custody standards, child support formulas, parental rights, relocation rules, and even how courts define the best interest of the child. And whether you're married, divorced, separated, co-parenting, or just starting a family, these changes matter more than you think. For years, many parents assumed that custody battles followed a predictable pattern. Mothers were often favored for primary custody. Fathers frequently struggled for equal parenting time. Child support was calculated using long-standing formulas, and once an order was in place, it felt almost permanent. But that stability is shifting. Courts are moving toward different assumptions. Some states are pushing for a presumption of equal parenting time. Others are strengthening enforcement mechanisms for missed support payments, and digital evidence, texts, social media posts, even GPS data, is now playing a larger role in custody decisions than ever before. Let's start with the biggest shift, the growing momentum toward shared parenting. In several states, legislation has been introduced or passed, creating a presumption that equal or near equal parenting time is in a child's best interest. On the surface, that sounds simple. Fair even. Two parents, equal time. But in practice, this changes everything. Because before, the starting point in many custody disputes was one primary custodial parent and one visiting parent. Now, in certain jurisdictions, the starting assumption is closer to 50-50. That shift creates tension. For some parents, it feels like long overdue fairness. For others, it feels destabilizing, especially in high conflict situations. Imagine a parent who moved out of the family home believing they would see their child every other weekend. Now they're told the court may default to equal time unless strong evidence suggests otherwise. Or picture a parent who has been the primary caregiver for years, suddenly facing a legal presumption that equal division is preferred. And here's where things get even more complex. The phrase best interest of the child remains the guiding principle in every state. But how courts interpret that phrase is evolving. Judges are placing greater emphasis on stability, mental health, and a parent's willingness to foster a relationship with the other parent. That last factor is huge. Courts are increasingly scrutinizing behavior that appears to alienate a child from the other parent. Angry text messages, social media rants, refusing reasonable schedule adjustments. These actions, once considered personal conflict, are now being viewed as potential evidence in custody evaluations. Technology has amplified this shift. 10 years ago, a custody case relied heavily on testimony and maybe a few witnesses. Today, digital footprints tell stories in real time. Parents have lost credibility because of Instagram posts contradicting courtroom statements. Judges have reviewed heated text exchanges that reveal hostility. Even location data has been introduced to challenge claims about parenting time. The courtroom is no longer isolated from daily life. It's connected to your phone. Child support laws are also undergoing transformation. Economic pressures, inflation, and changes in employment patterns have pushed lawmakers to revisit how support is calculated and enforced. Some states are adjusting formulas to account for shared parenting time more precisely. Others are tightening enforcement through automatic wage garnishments, license suspensions, and even passport restrictions for substantial arrears. At the same time, courts are recognizing that gig economy workers and self-employed parents present unique challenges. Income is no longer just a paycheck. It can fluctuate month to month. There's a growing conversation about fairness in child support, especially when parenting time is evenly split. If two parents share custody 50-50 but have different incomes, how should support be calculated? Some states are refining guidelines to reflect the real costs each parent bears. That means parents must understand not just how much they earn, but how the law interprets that income. Relocation cases are another area seeing heightened scrutiny. Imagine one parent receives a job offer across the country. Years ago, the court might have focused primarily on economic opportunity. Today, judges weigh far more variables: the child's community ties, school stability, extended family relationships, and the feasibility of preserving meaningful contact with the non-relocating parent. The burden of proof can fall heavily on the parent seeking to move, and the outcome can determine whether a family stays intact geographically or fractures across state lines. Domestic violence considerations are also evolving within custody frameworks. Courts are expanding definitions of coercive control, recognizing that abuse is not always physical. Financial control, intimidation, and emotional manipulation are being examined more closely. Protective orders can now significantly influence custody determinations, and judges are increasingly cautious about ordering joint custody in cases where credible allegations of abuse exist. Another subtle but powerful shift involves grandparents and third-party rights. In certain circumstances, grandparents are petitioning for visitation when family relationships break down. Courts balance parental autonomy with a child's established emotional bonds. These cases raise profound constitutional questions about who ultimately decides what is best for a child. Then there's the rising role of mediation. Many states are requiring parents to attempt mediation before proceeding to trial. The goal is to reduce conflict and court congestion. But mediation also demands preparation. Parents must negotiate effectively, understand their rights, and approach discussions strategically. The agreements reached in mediation can become binding court orders. Parental rights cases involving education and medical decisions are also surfacing more frequently. Disputes over schooling choices, vaccinations, mental health treatment, and religious upbringing are landing before judges. Courts often look at prior decision-making patterns and the child's established routine. Parents who previously deferred to one another may find that past behavior shapes future rulings. For unmarried parents, paternity laws continue to be critical. Establishing legal parentage is the gateway to custody and support rights. Voluntary acknowledgments at birth, genetic testing procedures, and deadlines for contesting paternity vary by state. Missing a filing window can have lifelong consequences. And let's not ignore the emotional weight behind all of this. Family law is not abstract. It's deeply personal. Every statute touches real families, real children who feel the tension of court dates and schedule changes. The stress of litigation can impact work performance, finances, and mental health. That's why awareness matters. Not panic, not fear. Awareness. One of the most surprising trends is the emphasis courts are placing on parental cooperation. Judges repeatedly stress that the parent who demonstrates flexibility and child-focused communication often gains credibility. This doesn't mean tolerating harmful behavior. It means showing the court that you prioritize your child's well-being over personal grievances. Parents sometimes underestimate how small actions appear in court. Canceling visitation repeatedly, speaking negatively about the other parent within earshot of the child, ignoring school events. These patterns accumulate. Judges look for consistency. They look for responsibility. There's also an emerging discussion around mental health evaluations in high-conflict cases. Courts may appoint guardians ad litem or custody evaluators to investigate family dynamics. Their reports can heavily influence outcomes. Transparency, cooperation, and documentation become critical. Documentation itself has become a silent ally for prepared parents. Keeping organized records of parenting time, expenses, medical appointments, and communication can clarify disputes. But documentation must be factual, not emotionally charged. Courts respond to evidence, not accusations. Financial transparency is another growing expectation. Concealing income, hiding assets, or manipulating employment status can backfire severely. Courts have broad authority to impute income if they believe a parent is intentionally underemployed to avoid support obligations. And then there's the long-term view. Custody orders are modifiable, but only under substantial changes in circumstances. Understanding what qualifies as substantial is essential. A minor disagreement rarely suffices. Significant relocation, job loss, or changes in a child's needs may open the door to modification. Perhaps the most important takeaway is this: family law is not static. It reflects societal shifts. As gender roles evolve, as economic realities change, as technology reshapes communication, the legal system adapts. Parents who remain informed can navigate these waters more confidently. There is tension in every transition. Some parents feel empowered by reforms promoting equal parenting. Others fear unintended consequences. But the central thread remains the child's best interest. Courts may debate frameworks, but that principle anchors decisions. So, what should every parent do right now? First, understand your state's specific statutes. Family law is largely state-driven. What applies in one jurisdiction may not in another. Second, communicate thoughtfully. Assume that written messages could one day be reviewed in court. Third, prioritize stability for your child. Judges consistently favor continuity. And finally, remember that while laws shape outcomes, your daily choices shape your child's experience. Legal battles can feel overwhelming, but children watch how parents respond to conflict. They absorb tone, patience, and resilience. The landscape is changing, slowly in some places, rapidly in others. But knowledge reduces fear, preparation builds confidence, and awareness can prevent devastating surprises. Family law is not just about winning or losing a case. It's about constructing a framework where children can thrive despite adult disagreements. It's about balancing rights with responsibilities. It's about recognizing that every courtroom decision echoes in a child's future. As reforms continue and courts reinterpret old standards, one truth remains constant: informed parents make stronger decisions. Whether you are navigating a current dispute or simply safeguarding your family's future, understanding these changes gives you power. Because at the end of the day, this isn't about statutes or procedures. It's about bedtime routines, school mornings, birthday celebrations. It's about the everyday moments that define childhood. Stay informed, stay intentional, and never underestimate how quickly the legal ground beneath your family can shift. The more you know now, the better prepared you'll be if that shift ever reaches your door.